Hello, everybody. My name is Chris Robertson. With me today is Ada Dolph. We are both partners at Seyfarth Shaw, and we are today going to do a program on our continuing Decoding Appeals. And today's subject will be with regard to interlocutory appeals. And what we hope to cover today is some of the bases for taking interlocutory appeals, and then some of the strategies in doing that, and then some best practices toward the end. So we look forward to sharing some of our thoughts with you on this topic. And we'll start with Ada, if you can sort of kind of walk through, the most popular we see, or one of the most popular ways to take an interlocutory appeal, which is under 1292A1. If you could kind of go through that and sort of when strategically you think a party should be thinking about taking that route.
Thanks, Chris. And as Chris said, I'm Ada Dolph. I'm a partner in the Chicago Seyfarth office and a member of the Appellate team at Seyfarth. So the 1292A1 appeals are used to appeal the denial of granting an injunction or dissolving an injunction, basically anything having to do with an injunction. And one phrase you're going to hear a lot as we talk through this is permissive versus as of right. These are the terms of art that describe whether an appeal is something that you get automatically or whether you're basically asking for permission in a permissive case for the right to appeal. So in the 1292A1 appeals, for the most part, these are as of right. But sometimes the courts will construe these as very narrow, or the relief sought as very narrow to the most dire situations where not getting an interlocutory order or not dissolving one has the capability of threatening serious irreparable injury. So it is as of right, but the courts will kind of take a look at the merits and the relief sought, as well as the potential harm, in determining whether to grant or deny that appeal. I don't know, Chris.
And so like an example of that, would that be, for example, if when you say irreparable harm, it might be that an injunction, as we've seen recently, there are various actions that have been brought against different of the current administration's policies, and we've seen those appealed immediately. Is that kind of the typical situation where the argument is, if I don't do this now, by the time the appellate court looks at this or corrects what I believe is an error, which is why you appeal, basically there'll be no remedy because things have already happened that can't be undone.
Yeah, that's exactly right. And we are seeing that a lot with the recent administration, just a significantly high number of challenges to administration policies and regulations, and even the rollback of regulations. So the arguments are often that unless that conduct is stayed, there will be irreversible harm. So, for example, in the instance of the citizenship issues that are being argued or were just argued in front of the Supreme Court this week, there's a discussion about whether, if it's allowed to proceed, whether there might be individuals who are losing out on benefits or deemed non-citizens. And that would be causing a significant harm in the challenging party's eyes. So the court talked a lot about how those harms might be addressed and whether they're reversible.
And then turning to, permissive appeals. So now you're in a case and you may have the opportunity to take an interlocutory appeal, but it's not mandatory. It's not an injunction. It's not something that you have the immediate right. What sort of considerations and discussions with clients should one have about whether to take that route in the middle of a case where it may not be granted and there are procedural steps in order to have that granted?
Right. So in general, with a permissive appeal, the likelihood of it being granted typically is relatively low. So some of the factors that I talk about with my clients are obviously the cost versus the benefit. Sometimes it can aggravate your presiding judge. So that's also something to keep in account. However, if you think you've got a good opportunity to prevail, then it's a worthwhile endeavor. It also can head off, costs and other things that would go forward if that sort of major turning point in the case isn't addressed in some different way. So they, although the likelihood of them being granted is lower, they can be very worthwhile, even with that small percentage.
So for example, if I'm in the middle of a case and I get a ruling on an issue, a claim is dismissed, or it could even be an evidentiary issue. And my concern is that that issue is now going to be so pervasive throughout the rest of the case and into trial, that again, I can't really undo it. Is that the type of situation where you'd say this may be worth doing?
Absolutely. An example of that that I'm aware of is, for example, there have been cases where the trial court has ruled that a large number of documents do not have the protection of privilege and will be revealed during the course of the trial. So in those instances, there's been numerous interlocutory appeals up saying this will be irreversible harm. The privilege here should be applied. And that's an example, I think, of what you're talking about.
Yeah. So for example, if a key document in the case, is disclosed, but really the argument is it should stay privileged either on an attorney-client privilege, or it might have some other privilege. That could, again, that's the kind of thing that could infect your case throughout, and you really can't undo at the end, right?
Yes, absolutely. So, and that's part of the strategy of litigation, is making sure you're evaluating every option you have when you face some sort of reversal in the case. So some of the opportunities you have to appeal that aren't, guaranteed, that are more on the permissive side, would be, for example, under 1292B, which is where you need to first go to your trial court judge and say, Judge, this is an issue that we really need an appellate court to take a look at. So that district court would have to certify that issue to go up to the appellate court. And then the appellate court would have jurisdiction over that and any sort of intertwined issues as well. But again, this has to be a pretty significant impact that will change the course of the case irreversibly going forward if it's not had an appellate court take a look at it.
And so in filing that motion with the district court, you mentioned that, you want to be careful because, obviously if you're appealing something in the middle of a case, that could antagonize the judge. Is there a sort of best practice or tone and tenor of a filing like that, to try to toe that line between, getting the relief you're looking for, but not antagonizing the judge?
Yeah, I mean, I think I always approach it from the perspective of I need to make my record. We happen to disagree on the impact of the court's most recent ruling. And in a very respectful way, we're asking for another party to weigh in on it. And I would focus on, as much as possible, if the area of law is unsettled, or the court sort of went out on a limb on something that maybe didn't have as much precedent support. Those are the kinds of situations where I think it's, you can legitimately say, well, we'd like to have the appellate court take another look at this.
So let's turn our attention now to Rule 23F appeals in the class action context. And I know you've had a number of these. So can you just quickly explain what a 23F appeal is and sort of the strategy and circumstances that might result in that, taking that tact in the middle of a case?
Absolutely. So you see the thread throughout all of these appeals that there's something that needs to be addressed urgently that will impact the complete, the full trajectory of the case going forward in a very significant way. And Congress has determined that class certification is one of those issues. So Either side can appeal the denial of class certification or the granting of class certification under Rule 23F. There's a very short window, I believe it's 10 days, to file that petition once the class cert order is entered. And essentially, you're going to the appellate court saying, I think the trial court got this wrong. It's significant. Either we're going to be proceeding with extensive class discovery, or we're going to proceed, with a single plaintiff case. And that is a significant difference from a litigation perspective, and something that you ask the appellate court to take a look at.
And so just to be clear, that could be the granting of class cert or the denial of class cert, correct?
That is correct.
And in fact, I have a case right now that there's an interim appeal in the First Circuit here in Boston where I am on a class denial. And the case is, as a single plaintiff case, is worth very little, but as a class action, it's literally in the billions of dollars. And is that sort of a typical break point, financially, for how someone would look at a case in that circumstance?
Right, absolutely. So even though the odds of a Rule 23F permissive appeal, so again, you're asking for permission. Now, you don't have to ask your trial court first. You can go straight up to your appellate court and ask for that permission. Even if the odds are low of that being reviewed, it can be very worthwhile in the circumstance you just described, where you have a significant amount of a difference in terms of the monetary impact of that class certification ruling.
So now let's turn our attention to Rule 54B appeals. Again, can you just explain what those are and the circumstances that might arise where you would take that route under 54B?
Right, and Rule 54B, again, it's a rare ability to be able to take this and ask the appellate judge to take a look at it, or the appellate court to take a look at it. Basically, what you're saying is that maybe there has been a judgment entered as to one part of the lawsuit or one claim that could impact how the rest of the case or the remaining parts of the case play out. And so that is an opportunity where you would say, okay, this is an issue that is severable from the rest of the case and deserves another look by a higher court, by an appellate court.
And so procedurally, how does someone, so now you've received a interim ruling that, falls under 54B, just procedurally, how do I tee that up for the appellate court?
You usually have to go, as I understand it, and ask the trial court judge to indicate that there's no just reason for delay on the appeal. So if the district court is entering an order on a claim and indicates that it's appealable under 54B, and you can make this request, or the judge may sua sponte add this information into the order. It's essentially saying then to the appellate court, this is something that we need resolved sooner rather than later in the case, and there's no reason to delay the review of it. Now, if it's intertwined with the other claims or the merits as a whole, it won't be an efficient use of judicial resources to have one appeal come up and then have another one come up later. So this has to be pretty much a discrete issue that can be examined on appeal on its own.
And the last topic is mandamus. Can you just quickly explain what a mandamus is, and again, how and why you might go that route?
Right, so mandamus is one of the most extraordinary reliefs sought, where you're essentially going up over your trial court, asking the appellate court to basically order something be done. So it means command to act. So if there's something, for example, that the government is not doing, that it should be doing, and there's irreparable harm, there's no adequate remedy at law. So if it goes forward or doesn't go forward the way it's supposed to, and you won't be able to be compensated for that harm, this is an instance where you would ask for mandamus. Now,
And again, oh, sorry.
Go ahead. No, go ahead.
Yeah, I was gonna say, we talked earlier about sort of how you might antagonize a judge. I would think in a mandamus situation where you're asking the appellate court to issue an order against the judge directly, that may be a very significant consideration as to whether to go that route.
Absolutely. And you balance that against the very low likelihood, honestly, that your relief, that you would get that appeal or that basis for appeal. It's really for rare situations. That said, we come across rare situations in our occupation, and there are times where it makes sense to pursue every avenue to an interlocutory appeal, including mandamus.
Well, thank you. I know this is a lot to cover. I mean, I'll just raise that there are a few other avenues that one can take an interlocutory appeal. For example, under the Federal Arbitration Act, if arbitration is denied, there's an immediate right of appeal. There's also appellate provisions, interim appellate provisions in the Class Action Fairness Act, CAFA. So if you're in a case, you're going to want to look and see if under the particular statute that you're operating under or the particular rules you're operating under, there may be an opportunity to evaluate, if you get an adverse ruling, whether to consider taking an appeal at that point in the middle of the case. But as we noted, that can delay the case. It can potentially antagonize the judge. And so you really want to have a clear understanding legally and procedurally and factually as to why you're taking that route, and understand the benefits of that, but also potentially some of the consequences. And with that, we'll wrap up today's session, and we really appreciate everyone's attention. Thank you very much.